webinar, and we will be making it available for everyone. Thank you all for joining in today's webinar. I hope that the information today will be helpful. My name is Erica Alfaro. A lot of you already know me. For those of you who don't, it's a pleasure to meet you via webinar. This webinar today will be going over tenant legal rights, and we have collaborated with Inner City Law, who will be presenting information to you all on tenant rights. And with me, I have Ingrid Arriaga. She is the supervising attorney of the HIV/AIDS Law Project here at Inner City Law Center. At her previous position, Ingrid was a Shriver attorney where she represented hundreds of tenants in eviction lawsuits. And Ingrid has been with Inner City Law since June of 2017. I also have Krista Daly. She's also a staff attorney for the HIV/AIDS Law Project. And she joined Inner City Law Center in June of 2018. And she has worked at the Greater Bakersfield Legal Assistance as a housing attorney. There she was a Shriver attorney assisting tenants facing eviction and other various housing matters. I apologize. I will head to the last slide. So I want to go over some housekeeping items before we move on. To get most of today's webinar, I wanted to introduce some features with Zoom. First, I recommend that all of you minimize your screen, and you can see it at the top. There's an arrow that says minimize screen. You will push that button. You will scroll to the bottom of the presentation where you'll see a ribbon with various widgets. For those of you who are having some trouble with audio, that's where you'll be able to access the audio for today's webinar. So everyone's line will be muted, so don't worry about interrupting the session. Everyone will be muted for today's webinar. And you will also see a chat box. So in the chat box, we encourage you to ask any questions, write down your questions in the chat box, and we will be answering the questions towards the end of the webinar. If by any chance we don't get through all the questions, we will provide you with an email where you can contact Inner City Law for any additional questions. We also have closed captioning available for this webinar. And if you'd like to access closed captioning, there is a widget at the bottom for you to access it. It will turn green once it's been enabled. Again, I'll be recording this webinar and we will be making it available for you all. And I will also be sending some resources for you all after the webinar. So we're gonna go ahead and begin. And before we get into any content, I'd like to make a few acknowledgements. First acknowledgement I want to make is for HCIDLA for giving us the opportunity to conduct this webinar, and of course Inner City Law for collaborating with us to deliver this webinar. And finally, ATLA Health and Wellness Shared Action, who've helped to put many of the supportive trainings and webinars together. So with that being said, I'll hand it over to Ingrid. I'm using the arrow, just clicking the arrow. Okay. So Krista is going to start us off with lease agreement.
Okay. And so the first thing that you want to advise your clients about, written lease agreements, it's really important that they carefully look at the terms of the lease and follow those carefully, especially in regards to number of occupants that are allowed at the property, pets, any pets they have need to be like specifically on the lease, and allowed by the landlord, and then parking spots need to be assigned. Those are some common issues that come up with written lease agreements. As far as oral lease agreements, the important thing to know about that is even if you don't have a written lease agreement, you still have the same tenant's rights as if you had, like a written lease. And then you also want to make sure to advise your clients not to sign anything that they don't understand, and also not to sign something that's substantially different than their current lease agreement, but that's specifically for rent control properties. So paying the rent, you want to always advise clients to pay the rent on the 1st of the month. Unless they have something in writing that says they can pay it on the 5th or the 13th, they have to pay on the 1st.
I'm on a webinar.
A lot of tenants tend to
doing it all. No, I'm joking.
Tend to think that because they've been paying on the 10th for 6 months that this is allowed, that they can technically be evicted with a 3-day notice starting on the 2nd of the month. Never pay in cash. That's very important under any circumstances. And that's mainly because you have no proof that you ever paid it. You're basically giving the landlord a gift and he can come back for you for the money. So with paying the rent, you always want to keep proof that you paid it. That means if you're paying in money orders, have the client keep the money order stub. Take pictures of the entire money order before they give it to the landlord. If they're using personal checks, I don't like my clients using personal checks because if you don't have sufficient funds, then you expose yourself to being evicted for it. So just making sure that you have sufficient funds and making sure that you have sufficient funds until it's cashed, because a lot of landlords will sit on a check for a while and then clients will spend the money in the meantime. If they're paying by mail, tell them to send it certified mail. That way you can track the payment. If they're paying in person, tell them to get a receipt. Even if a lot of landlords will refuse to give receipts, at least ask for one. And if they're not giving receipts, that's when you tell your client to take a picture of the money order or the payment. Making sure that they write their money orders and their checks is also very important. They have to write down the month and the year of when they're giving the payment for. So, and if they're paying SCEP, if they're under a rent control property, you want to write that down. Okay. So as far as pets and companion animals, if pets are not allowed by the landlord, but one of your clients has an emotional support animal or service animal, you need to get documentation, medical documentation that they need that emotional support animal. It's really important to notify the landlord in writing and send medical documentation before bringing the pet onto the property. So they shouldn't, get a pet before and try to do it after. It's really important that you get permission or get medical documentation before you have a pet at the property. So adding new tenants. A lot of clients will have their friends or a new partner stay with them and not ever tell the landlord. It's very important to get everyone that's living there on the lease and getting permission from the landlord. It's very common to get evicted for having someone stay with you and the landlord finding out. It's very easy to get evicted for that. So making sure that the landlord is notified and that the landlord approves it, because many of the leases require that the landlord approve any new occupant living with the person. And this is especially important if they have a Section 8 voucher. Section 8 vouchers specifically state like who's on the voucher, who can stay with the person. So that's also another layer to worry about, because if they have an unauthorized occupant, they can get evicted by the landlord and also get terminated by the housing authority where they get their Section 8 voucher. Issues with poor housing conditions are another thing that can come up, and so like clients who have issues with plumbing or heat not working or pest issues, things like that. It's really important if those issues come up to document those issues. So the first thing is obviously to take pictures of the issues with the property and save those pictures somewhere where they're safe. And then also they should notify their landlord in writing of the issues and keep copies of them. It's very common for people just to tell their landlord verbally that there's problems going on, but it's really important to tell clients that they need to start keeping documentations of those things, and so keep copies in writing. Issues with pests and bugs specifically, they should make a complaint to the Department of Health, and there's a link to a website there where it can be reported. With everything else, you can make complaints to the Department of Building and Safety and to HZLA. Okay, so now we're going to get into evictions. So this is under California law. So meaning if the property is not under Los Angeles rent control. So under California law, a landlord can evict a tenant if the lease has expired. So if they sign a 1-year lease and they're still there after 1 year, you'll get evicted for that. Failure to pay your rent, that means paying your rent late as well. Causing a nuisance or destroying the property, that means making loud noise, throwing parties, anything with drugs or violence, that can be a nuisance or unlawful purpose. And also if a tenant gives 30-day notice and then they change their mind and they're still there after the 30 days, the landlord can evict for that. So now we're going to talk about properties that are under rent control, and just generally, you know, properties will fall under rent control when they're within LA city limits, built before October of 1978, and the property is 2 or more dwellings on the same property. And also just to add to that, sometimes if a house is converted into different units, multiple units, which is happening a lot in the city, so there's multiple people living in a single family home, they each have a different lease, that can sometimes be protected under rent control as well. So now we'll get into the common reasons for evictions under rent control. So if a property is under rent control, that means the landlord has to follow the law under what we call it LARSO, not just under California law. LARSO is a further protection. So the common reasons that people get evicted under rent control properties is failure to pay rent, and that means if you're paying rent late. So even if you end up paying your rent, but it's late repeatedly, and after you get a 3-day notice, you can still get evicted for it. Second reason is if you're violating your lease. If your lease says there's only 2 adults in the unit, but there's actually 3, you can get evicted for that. Or you're using someone else's parking spot and you don't even have a parking spot, you can get evicted for that. Committing a nuisance or causing damage, that's throwing loud parties, making a lot of noise, or destroying the property. Refusing access to the unit, that means if your landlord is giving proper notice to the tenant, that means 24-hour proper notice in writing that they want to enter the property to make repairs, and the tenant is refusing that could be a reason for eviction. So it's very important that tenants let their landlords in if they're getting notified at least 24 hours in writing that the landlord is going in. Under rent control, a tenant can get evicted for the landlord seeking the unit for themselves or a family member or resident manager. That's not very common, but it does happen.
or if they're seeking possession to comply with a government order. That's also not very common, but it does happen.
And so some further rent control protections are, so protections that tenants have if they fall under rent control. You know, the rent should not be increased by more than 3% once a year. A new owner buying the property is not a reason for eviction, and so a lot of new owners will try to evict old tenants, or people selling the property will try to evict the tenants because they're selling it, but under rent control, that's not allowed. That's not a reason allowed for under the rent control code to evict the tenants. Tenants also can't be evicted just because the lease term has entered. And then rent control also regulates cash for key agreements. And so agreements where landlords will offer money for the tenants to move out. Tenants are not required to agree to those kind of offers, and they have a certain amount of time to rescind, even if they did initially agree to some sort of agreement like that. So if they initially say, okay, I'll move out, but then they go and get legal advice or they think about it, they can rescind that offer. And then also landlords must file a notice with the housing department of the agreement.
So Section 8 vouchers, evictions by landlords. So if a tenant has a voucher and is living in a rent-controlled property in LA, the landlord must follow Los Angeles rent control law. So that means they can't terminate Section 8. A lot of landlords will buy a property that is rent-controlled and Section 8, and then they'll want to terminate, they'll want to stop with the Section 8 program, so they'll send tenants notices that you now owe me full rent, I don't want to do Section 8 anymore. That is illegal. So basically, owners are stuck with Section 8 if it's a rent-controlled property. They must follow the rent-controlled rules, so they have to find a reason under rent control to evict them. If it's not rent control, then they can be evicted with a 90-day notice. The landlord doesn't need a reason at all.
So tenants who receive Section 8 can also be terminated by the housing authority, and so they may receive some sort of notification that the housing authority is terminating their voucher for one reason or another. The most important thing with that is that they need to request a hearing in writing very quickly, because you only have 90 days to appeal from the date of the termination. So it's important that once they get it, they request a hearing right away. And you can also refer them to us for representation in those hearings.
So just to clear that up a little bit, so a hearing has to be requested usually within like 5 or 10 days. But if they do end up going to a hearing, which a lot of tenants do by themselves, then once they get a decision, you only have 90 days to file an appeal, and that's called writ. So at that point, it's very important that you refer those decisions to us, because the time starts running for us to file papers in the court. And once the 90 days are up, it's over. So a lot of tenants will be living in an apartment building or a duplex, and they start getting notices from the bank that the property is being foreclosed on. If that happens, and if it's under rent control, they can stay, even if it's bought by someone else. if it's bought by an individual, a lot of individuals will buy foreclosed properties and try to intimidate tenants to leave. They are pretty much stuck with those tenants. If a new landlord, if a new homeowner, if a new apartment owner buys a property with tenants in it and it's rent controlled, they are stuck with those tenants. They have to follow the rent control laws. Here in LA, there is a Los Angeles foreclosure moratorium that keeps getting extended. There have been several expiration dates, but it keeps getting extended by the city council. So it applies to even single family dwellings. So even if there's a single family home and it's been foreclosed on, that home essentially gets all the protections of being a rent controlled property. So the owner or the bank can't evict just because it's been foreclosed. They have to follow the rent control laws.
Okay, and so this is kind of an overview of the eviction process generally. And so the first part of that process is a tenant will be served with some kind of notice, and it depends on kind of, some of the different reasons we talked about as to why landlords can serve notices. And so depending on that, it'll be like a 3-day notice, 30-day notice, 60-day notice. Once the time on that notice passes, at that point, the tenant can be served with the actual lawsuit, and so a summons and complaint through the court. Once they receive that, it's really important to respond that the tenant file an answer within 5 days. They don't respond during that time, the landlord can enter a default against them, a judgment, and they won't be able to go to court and have a trial. So the most important thing is that the tenant file an answer with the court within 5 days of receiving the summons and complaint. From the time that they file an answer, it's about, you should expect about a week after that until you receive a notice of trial, telling the tenant when they need to go to court. And from that time, the court sets the trial date within 20 days. So it's a few weeks until the actual court date. And at trial, they have, there's some different options. And so sometimes the landlord will decide to dismiss the case for some reason. There's a problem with what they filed, or, the tenant goes ahead and pays if there's unpaid rent, and it will get dismissed. But if not, either basically the case will go to trial, or they can settle and try to work something out with their landlord, either to stay at the property, if there's unpaid rent, pay some of that back, or to move out, and the landlord agree not to pursue any money or against them. Depending on what happens, obviously if they go to trial and win, you just stay at the property. If you lose, you get a notice to vacate, and it usually gives you about 5 days before there's a lockout by the sheriff.
So we're just going to show you some documents of how the eviction process starts. So the first thing is you get a notice. Most of the tenants that we get referred are starting out with a 3-day notice to pay rent or quit. So if they get this notice, they have to pay within 3 days. And that means Saturday, Sunday. If the 3rd day falls on a holiday, then you'll get 1 more day. And also, if the tenant has the money, you have to read the notice very carefully and pay the way it asks you to. So it usually say, pay at this address during these days at this time, and it'll tell you if you can walk in person, or if it wants you to pay by mail. The 3-day notice to pay rent or quit may have different instructions on how to pay rent than how the tenant usually pays the rent. So let's say they usually pay their rent by going to the on-site manager next door to them for the past 10 years. But then they get this 3-day notice, and it's saying you have to travel 5 miles to this office to pay the rent. They have to do that. They can't just go pay the rent next door like they always have. And usually they'll post the rent. They'll post this notice. They'll just tape it onto their door or mail it.
And so this is just a sample of what an unlawful detainer complaint looks like. And so this is what the tenant would be served with. And if they're served with an eviction, there's a summons also that goes on top of it, but this is what the first page looks like. So if they receive that, like I said before, the most important thing about that is they just go to the court immediately and file a response.
So this is what an answer looks like. So if you have a client that's been served with a complaint, that's when you need to refer them to us, like immediately, because the 5 days are running and we're on a time crunch to file an answer, and that means 5 days, including Saturday and Sunday. So the time goes by very, very fast. You can refer them to us, and we can assist with the answer. If you're unable to contact us, or we're unable to see the client in time, they should go to the courthouse that is written on the lawsuit and file an answer themselves. There's usually a self-help center at every courthouse, and if they do that on their own, they can still come to us immediately after, and we can fix whatever they filed. But we only have 10 days to file an amended answer. And this is what we'll file along with other legal documentation.
And I see some questions coming in. Again, the questions will be answered at the end. So we'll get back to your question.
And another reason why to refer the clients immediately to us is that we're also requesting jury demands. So we demand a jury trial on every eviction case because it gives the tenant leverage to negotiate a better deal. And we only have time to file a jury demand, a very limited amount of time. If the time runs out, then we can't do that anymore. And so this is what a tenant should do when they decide to move out, if they decide to move out of the property. And so the first thing is that they need to give written notice per the terms of the lease agreement. Usually that's 30 days, but I mean, it does just depend like what their lease says to do. They want to take pictures before they move out of the unit so that they can see what conditions it's in. And also if the landlord, tries to blame them for any damages that they didn't do, they have proof of what the condition of the unit was in when they moved out. For the same reason, they should also schedule a walkthrough with the landlord before they move. In terms of the security deposit, a landlord has 21 days to give them the full security deposit back or an accounting of it. So like an explanation of what they're taking out for, what damages they're charging the tenant for. And again, that's like why it's important to do the walkthrough and take pictures before moving. If you don't receive the deposit or the accounting within 21 days, they can sue in small claims court to get the security deposit back. So this is our new referral form, and this referral form will be given to your managers, and you will have it. We're asking you to use this form instead of the old form that you're using. And so basically filling out it's the same type of information, filling out your information and the client's information, and then writing a brief summary
just a few sentences or whatever you need to tell us what's going on. If it's a housing issue, public benefits issue, or other. So we will receive referrals, accept referrals if it's a housing issue, public benefits, which means SSI, SSDI, CAPI issues. We're taking very limited immigration cases, but we'll accept the referral. Any employment discrimination or housing discrimination, we'll accept the referral. And when you're sending the referral, if you can please also send the most recent diagnosis form. It's easier for us to continue assistance if we can get it from you guys. And then any proof of income with the client for the client too. And you can send this referral form through our email at hopwa@innercitylaw.org or through fax. And then our paralegal Erica will contact the client or contact you if we need more information.
All right, so I know one person added a question, but if you have other questions, go ahead and type them in now. And I will go ahead and pass those along to Ingrid and Krista so that they can answer it for you. And I'll start off with the first question that came in. Can the 3-day notice specify a different payee from whom the tenant is usually pays rent to?
Yeah, I think it can. I think it can. So like I was explaining before, the notice to pay rent has very specific instructions. So it's really important to read the notice carefully with the client. And it'll give you specific instructions of how to make your payment in person, or who to make the payment out to. If you don't follow the instructions correctly, then it will not be a valid payment within the 3 days. So yeah, if it's asking for a different payee, I think that can happen. Yeah.
All right. Does that answer your question to the person who asked? And then again, use the chat box to insert your question so that we can go ahead and pass it over to Ingrid and Krista. So what came in, they wrote back, thanks. This becomes an issue if HOPWA assistants like STRMU can only cut checks according to lease.
Yeah, that is a big issue, and we've seen it before. But unfortunately, in court, it doesn't hold up. I mean, we can try to argue, make some sort of legal argument that that's how they usually pay rent, but usually the law states you have to pay how the 3-day notice instructs.
All right. Can we do anything to get cooperation from the CCA? Central Coordinated Agency?
I wouldn't be the person to ask about that. Not sure.
So for that one, I think, Ron, the best thing to do is maybe contacting the CCA. Yeah, contacting them in directly and maybe asking them additional questions that may provide you some clearance and guidance. He said, wish us luck. Any other questions? We still have quite some time. Okay. Does the housing authority send a notice to the client when they will not be receiving a moving voucher?
I don't think so. Like send a written notice if they request one.
Not that I'm aware of. Not that we're aware of.
Okay. I think they just tell them, as far as I know.
And sometimes the best thing to do when it comes to CCA and the Housing Authority, having a point of contact as to, who to ask some of these questions to. So that way, again, you can have some clearance and guidance to some of the questions that you may have, specifically for, let's say, Housing Authority or the CCA. Any other questions? Sometimes landlords issue 3-day notices without being serious about summons. How seriously should clients take 3-day notices?
Very serious. It's pretty much, you're on your way to an eviction lawsuit. Once you get a 3-day notice, you only have 3 days before you can legally be sued, and the eviction can be filed. So I know, I'm guessing what this person means is a lot of landlords will give eviction notices and not file anything afterwards, but you got to take it seriously every time, and just try to get your rent paid within the 3 days, because you never know when they're going to exercise their right to file an eviction. I'm guessing the landlords are just serving 3-day notices in case they decide to do it one day.
And then the next question following up is there a limitation on how long after 3-day notice landlords can sue?
Not really. Yeah, a lot of landlords will serve a 3-day notice and not sue until a month later, and that's very common.
Mm-hmm. I mean, I think it can't be a year later, right?
Yeah,
because you can't sue for something that's more than a year ago, but besides that, there's not really a limitation.
But the tenant should still, if they have the payment after 3 days, they should still try to pay the rent and see if the landlord accepts it. Because if the landlord accepts it on the 5th or the 10th day and cashes the check or the money order, then that's a legal defense to the lawsuit if they go ahead and still file an eviction lawsuit.
Any other questions? Again, the referral form that Ingrid talked about in the last slide, I will be sending that to the program managers. So program managers, if you are logged in, keep an eye out for that email. I'll be sending it to you so that you can all distribute it to the housing specialist so that they have it available at hand and use it when needed, especially if they have any clients who may be experiencing any type of legal issues.
Also, I just wanted to add something. Sometimes, a lot of times, it's very common for landlords to file eviction lawsuits and not serve the client. So the way that clients find out that they're being evicted is they'll get something in the mail from the court saying someone is suing you. And if they get that, that's when the referral needs to come to us immediately, because that means there's an eviction lawsuit. It's probably beyond the 5 days to answer at that point, and we have to go in and file a motion in the court. And every day that we wait is worse and worse for the tenant. Also, sometimes tenants don't get that notice in the mail either, and then the first time they know that they're getting evicted is they get a sheriff's 5-day notice lockout. And then at that point, it's not too late. As long as the tenant is still in the unit, hasn't been locked out, you can refer them to us. There are motions that we can file if there's a good reason why the tenant didn't know about the lawsuit. There are ways to stop the sheriff from locking them out, even if this lockout's going to be tomorrow.
Other questions? And we will be providing you the contact information to be able to ask any questions directly to Inner City Law. And here you can see their email address as well as their phone number and website. How does the client know if eviction will indeed be on their permanent record?
An eviction goes on your permanent record here in California if they didn't file an answer to the lawsuit and an eviction judgment was entered. So that means if they didn't file an answer, or if they actually went to a court date or a trial and they lost, then it will be on their record. They can check, they can go to the courthouse and see what happened to the case and see if the judgment was entered. If the judgment was entered against the tenant, it's on their record. I think they can also check their own credit reports to see if it's on there as well. And if there's an eviction on your record, it stays on there for 7 years. And then they're also on a national eviction registry, which follows you everywhere.
So the following was, I heard that Inner City Law can prevent it from getting on their record, even if they lose the case. It has to be on a case-by-case basis.
I have had tenants come in and see us where the judgment was just entered against them, and then we sometimes can negotiate with the landlord to see if they'll seal the record, meaning make it confidential. But it has to be right after it happens. I'm talking days, not months. We have received some referrals where an eviction judgment was entered years ago, and there's no way to get that off.
So we still have about 15 minutes left, and this would be a good opportunity if maybe you are experiencing a client who may need some legal assistance. It's a great opportunity to ask, since we have Ingrid and Krista here to answer those questions directly. Again, you can send them an email or you can leave them a voicemail with the phone number that's available on this slide. Don't be shy, guys. And you can also, if you choose not to put your question for everyone, you can choose to send the question to me privately, and I'm reading the questions to the attorney. It seems that there aren't any questions coming in. Again, this webinar is being recorded and I will make it available. Once it does become available, I will send an email to everyone. I do want to mention that I will send an email with an evaluation form. It is required for you to complete the form to get credit for participating in this webinar. If you have any questions in regards to any of the webinars coming up for the housing specialist or the supportive trainings, always feel free to contact me. Again, I'm Erica Alfaro. And again, if you have any questions in regards to legal rights, you can contact Ingrid and Krista with the email on this screen. And with that being said, since I don't see any more questions coming in, we're going to end this webinar. Thank you all for participating and taking the time out of your day to join us. And I hope you all have a wonderful day. Thank you all.